most of us have seen the video of Calgary street pastor Arthur Pawlowski and his brother David being dragged off to jail, quite literally, for defying public health orders. They were slapped with fines and a censorship order, but they appealed those sanctions, and on July 22nd, the Pawlowski brothers, along with Alberta restaurant owner Christopher Scott, had their appeals granted. The Court of Appeals said their arrests, jail time, censorship orders, and fines were all illegal, and now Alberta Health has to reimburse the Pawlowskis for the fines paid. Their lawyer, Sarah Miller, joins me now from Calgary.
Thanks for having me.
Sarah, you and I were talking a little bit earlier how this whole case was kind of lumped together with Christopher Scott, who you actually did not represent, and the Pawlowski brothers didn't even know him up until now. So now they're all kind of almost synonymous when people think about them because of this appeal that happened. So first of all, congratulations on winning that appeal for them. I spoke with Art last week, and he is extremely happy about this. How are you feeling? Was there anything about this case that kind of came up and surprised you?
Well, I'm not surprised that the Pawlowskis and Chris Scott have now become synonymous. I actually sometimes wonder if that was part of the strategy for Alberta Health Services, because they were very clearly targeting Chris Scott when they went and got their order, when they were pursuing the contempt. The Pawlowskis kind of got lumped in there. And so the more that people saw Chris Scott and the Pawlowskis as the same, kind of the better. Better when they got results out of the court, better for public image from the Alberta Health Services point of view. So it was very kind of frustrating, but also unsurprising that the Pawlowskis were kind of treated synonymously with Chris Scott. And finally, we've gotten to the Court of Appeal, and the Court of Appeal says, no, Chris Scott, yeah, you can be sanctioned. You know, what you were doing was contrary to a direct order from the court. Pawlowskis, they had nothing to do with this. They shouldn't be found in contempt at all. And so we finally have the Court of Appeal coming in and dividing those two. Chris Scott has been sanctioned, albeit much more appropriately than what he initially was. And the Pawlowskis are off completely scot-free, and Alberta Health Services has to pay them for their costs.
That's just absolutely incredible. So, Sarah, what are the next steps in this case now that you've won this appeal for your clients? And do you expect that the government might appeal this appeal?
Because the Court of Appeal was unanimous, I'm really hoping that they won't pursue any further appeal. It would be, in my estimation, it wouldn't be successful. I feel very confidently that the Court of Appeal has done a very sound analysis here, and that the Supreme Court of Canada has far better things to do than to hear whether or not the Pawlowskis should be in contempt of an order that was never served on them, never explained to them, and never named them. I mean, it just seems like a big waste of government resources, and the government is already on the hook for $50,000 at this point. So, I mean, I don't think it would be a good use of government resources, but that's up to them. So I don't expect them to appeal, but of course, there's all sorts of things I don't expect Alberta Health Services to do in this matter that they have. So we'll see where that goes. I suspect that this matter is now concluded, but because of this matter being in the courts, being successfully pursued at the Queen's Bench level, the Pawlowskis were subject to a probation. They've been charged since with breaches of probation for attending peaceful protests. And they've also been charged, or Artur Pawlowski has been charged with criminal contempt of that same order when he attended a baptism service in June 2021. So I'm currently trying to work with the Crown Prosecution Service to get them to understand the decision from the Court of Appeal that really takes all the wind out of their sails for those criminal charges. I've not yet heard from them that they're going to withdraw, but hopefully that will be soon. So that's our next step, is to get these other knock-on effects caused by Justice Germain's order and the probation that they were under for so long to be and his finding of contempt, which was wrongful and not anchored in law, as the Court of Appeal has found, have all those knock-on effects get dealt with and taken away as well.
Right. So it goes on and on. So Sarah, do you think that this appeal win could help set any precedents for other cases?
Yeah, I mean, In a way, yes, but only because Justice Germain's order and decision was so antithetical to what we usually see in contempt proceedings and contempt decisions. So it's the Court of Appeal decision really just goes back to all that other case law, that we cited extensively to both Justice Germain and the Court of Appeal to say, hey, this is what the law is. We treat protesters in a certain way. We have to balance interests between different parties. And this is how you successfully obtain an injunction order, how it should be applied, how you can get contempt under it. And so the Court of Appeals really just reverted to that ordinary understanding. It was very important to run this appeal though, because not only did it, punish the Pawlowskis in an unreasonable and inappropriate manner, um, the decision of Justice Germain, if we had left it standing, would have been very problematic going forward for anybody who wants to protest or exercise their freedoms of assembly and expression, that now they're subjected to a whole easier test to achieve. So it's not precedential in the sense that it's created new law for anyone.
Okay.
Certainly not, but it is precedential in the fact that we've now corrected the law that was kind of misaligned there for the past year.
Yeah, it's interesting. Is there something in this case that really stood out to you? I know you were mentioning before that they were never even named in the whole process.
Yeah, this whole process has shown me that the fear that is a reasonable emotional response in many circumstances has driven a lot of um, I think the public's response to this case on both sides. The Alberta Health Services strategy to pursue it when it may have should have been clear to them that they shouldn't have, and the decision out of the Court of Queen's Bench. Fear was like the predominant thing that I felt when I read the decision out of the Court of Queen's Bench, going on and on about the pandemic and the harm of the pandemic, and language like, well, everybody knows at least one person who's died of COVID-19 in Alberta. And like that, just like to write that in a decision when at the time the rates were, I think you had to know over 1,300 people before you statistically might know one person who had died of COVID-19. It was so illogical and fear based and not rational. But that was very surprising to me because we come to law thinking, we're Vulcans of some nature, that we only do rational thought and legal reasoning. And it was really lacking throughout this process until we got to the Court of Appeal. So it was surprising to me because I thought that the courts were a bit more immune to that than what they seem to be.
Can you maybe explain a little bit more about how the brothers weren't ever even named by the government? They explain that a little bit maybe for our viewers.
Yeah, so when a big, development company or the government wants to get an injunction to prohibit protesting, they have to go to the court and get and satisfy a certain test. And of course, they don't necessarily know every protester who's going to attend a protest or a rally, right? So it would be nearly impossible if the burden was you must name every single person who's going to be there in this order for this order to apply to them, right? So we accept that there's a little bit of an unknown here. If you're doing a forestry project in BC and you've got a bunch of environmentalist protesters coming, you can't name all of them. So you're going to use something vague, the organizers that you might name the organizers, you might name their organization, right? You might name anybody who you can, and then you'll say something vague like John and Jane Doe, which will capture other people as long as as long as they can read the order and say specifically, "Oh, this is me," right? So it usually has to be very tight language to say, "This is this event, this location, these people are prohibited under this court order." Now, last spring, the Alberta Health Services went into court without notice to anybody, in this kind of secretive manner. And I only say it, you can go into court without notifying other parties, and that's called an ex parte proceeding, and that's normal. But the secretive part was that they had the court recordings turned off on May 5th, the first day that they were in court before the justice. So that's the secretive part, that whatever they said in court that day has not been recorded. We don't know what was exchanged. The next day they come back with this order that they get ex parte, which is permitted, and that order was naming Chris Scott, Glenn Carrot, an associate of his, Whistle Stop Cafe, which is or ran, I should say, by Chris Scott, and those acting in concert with them under their instructions or independently to like effect. And it was this very vague misunderstanding of what does that mean independently to like effect, right? Does that according to the first decision that we got out of the Court of Queen's Bench, we were supposed to read that as Albertans as it applied to every single one of us. Every Albertan in the province of Alberta was supposedly subject to this order as long as we got notice of it. And actually not even notice, because the notice provision was in the order was not complied with either of Arthur or David Pawlowski. So all Albertans who may have a sense of this order being in existence or having it placed at their feet with no further explanation could be captured by this order. That was the impact of Justice Germain's decision. That is unprecedented in injunctions. We don't go into the court, and the court does not generally grant injunctions to say the whole province is now prohibited from doing something, right? Like, so peaceful protesting, but that might exceed the gathering restrictions or exceed the gathering restrictions. Instead of being subjected to a ticket procedure, which is drafted under legislation, under the Public Health Act, under its related regulations. Usually, I go into Calgary, I protest, I gather in excess of 10 or whatever the limits are, you get a ticket. Well, now this order is in place and we're supposed to assume it applies to all of us and we can all be incarcerated, thrown into jail for 3 days, subject to bail conditions, probation, further incarceration, huge exorbitant fines that are larger than what the legislation says we should be getting. That's, to me, illogical. But apparently it made sense to Alberta Health Services and Justice Germain. So that's why the order never mentioned them. It had this very vague language as to independently to like effect. And Calgary Police Service enforced it against the Pawlowskis. Alberta Health Services pursued it against the Pawlowskis. And the Court of Queen's Bench decided against the Pawlowskis that meant everybody in Alberta.
Oh my goodness. Okay. Was that the part of it that was sort of illegal in terms because they sanctioned them without even really naming them?
Yeah, so and like I said, if it was somebody who was very clearly part of Christopher Scott's under his instructions or working with him to run the No More Lockdowns rodeo, we might be having a different conversation, a different analysis. But because these were unnamed people who had nothing to do with what the injunction was really about.
Okay.
That was the legal part. Not just that they were unnamed, right? Not just that we
Got it.
didn't know their names or
Yeah.
that they were unnamed, but that they were so wholly and completely removed. They're 2.5 hours south of where Chris Scott was doing a church service rather than a No More Lockdowns rodeo. And never even spoke to Chris Scott at that point. Didn't, barely knew who he was. So that was the concerning part. They certainly weren't, colluding with him to run a similar No More Lockdowns rodeo at a different location because the first one had been found out by the government.
Okay. And Sarah, really quick, could an appeal like this possibly lead to grounds for a civil court case for damages caused by the actions of the government for individuals within government?
So it there's I guess there's always the chance that information might come to light where we could actually pursue something against the government, or the Pawlowskis could pursue something against the government. The tort, the civil claim tort that would likely be in play is a malicious prosecution. Governments, or sorry, courts are very reticent to find that there has been malicious prosecution. They're very in favor of granting government actors like a fairly large leeway of ignorance, negligence, having a bad day, those types of things. So I think even one case says, you can be grossly negligent but not malicious. And so it's not the easiest test to make out.
Hmm.
It may be in this case that there was just gross negligence and not maliciousness. So our remedy is really getting the costs from Alberta Health Services, which is in the ballpark of
Okay, so
$50,000.
do you think that maybe some individuals would have grounds for civil court actions if they wanted to seek restitution for damages caused by government during COVID lockdowns, for example?
Yeah, I don't think this case would be the one to support that. I know that Justice Center for Constitutional Freedoms, they're doing a case, Ingram. If that case is successful, that might be the case that you would look at, the
More,
analysis
a little
from the
bit more
court and see
groundbreaking.
if yeah, a little
Okay.
bit more groundbreaking.
Okay.
This one was very particular, and the Court of Appeal was very careful to, say, the this isn't a decision about whether or not the government can issue lockdown orders. This isn't a decision about whether or not Alberta Health Services can go in and get an injunction. And this isn't about whether or not injunctions can name unnamed individuals like John Doe, Jane Doe. This is really about, how do you get contempt of court? And did Alberta Health Services satisfy that test? And they didn't.
Very, very interesting. Sarah Miller from JSS. Barristers in Calgary, thanks so much for joining us today and for sharing a little bit about this case that everyone's talking about this week.
Absolutely. Thanks for having me.
I'm Jeanette Roche on behalf of all of us here at Bridge City News. Thanks for watching.